Welcome to Knowledge is the Power. Friends, in this video we will discuss on the topic Right to Information Act. This video will helpful for the examinations, AAO examination, Inspector Post examination, PS Group B examination and any other competitive examination based on Right to Information Act 2005. In this video we will discuss on the topic Introduction of RTI, brief overview of Right to Information Act, meaning of information, meaning of record, right to information, public authority, appropriate government, competent authority, third party, dealing with the information sought by the citizens making a request for information under the RTI Act, disposal of request for information, scale of pay, information exempted from disclosure. First one, introduction. The Right to Information Act 2005, which will fully came into force on 12th October 2005. It is the one of the most significant legislation enacted by the Parliament of India. It means RTI Act 2005 came into force on 12th October 2005 after the 120th day of its enactment, and it is the most important legislation enacted by the Parliament of India. It aims to ensure maximum openness, transparency and accountability in the machinery and functioning of government at all levels, central, state and local level of administration. RTI aim is to ensure maximum openness, transparency and accountability in the working government. The Act provides the citizens the right to appeal. Under this Act, citizens can make appeal under the information provided by the authority. The first appeal against an office action or inaction of a public information officer to an appellate officer who is to be senior in rank to the PIO. If the information provided by the public information officer is not satisfied by the applicant, then he can make first appeal against the information provided by the public information officer to appellate officer. Normally, appellate officer is senior rank than public information officer. The Act also mandates the constitution of information commissions. Under this Act, the information commissions have been constituted at the central level. The Central Information Commission (CIC) and also at the state level, the State Information Commission (SIC) have been constituted to inquire into complaints. Second appeals oversee and guide the implementation of Act. Accordingly, the authorities prescribed under the Act are constituted at various levels. Brief overview of RTI Act. Obligations of public authorities. Designation of public information officers and assistant public information officers. Constitution of Central Information Commission and State Information Commission. Non-applicability of the Act, Intelligence and Security Organization. This Act will not applicable to intelligence and security organizations. Power to make rules to carry out the provisions of Act by the appropriate government and competent authorities. The Act covers all public authorities, include bodies established or constituted by a law made by the Parliament or state legislature. The Act also includes non-government organizations which are substantially financed directly or indirectly by funds provided by the government. Under this Act, non-government organizations also included which are financed by the directly or indirectly by the government of India. Under this Act, every public authority has to publish, among other information pertaining to, every public authority has published the following informations. First one, organizations, functions, duties, norms for discharge of functions, procedural details. Next, categories of documents held, rules, regulations, instructions, manuals, and records, statement of boards, councils, committees, and other bodies, whether meetings of such bodies or minutes are accessible to public. Remuneration of officers and employees, budget and expenditure, manner of execution of subsidy programs and beneficiary details, particulars of receipt of concessions, permits of authorities granted, particulars of facilities to citizens for obtaining information, details of public information officers, the limit for disposing request to the PIO specified in this Act. If the PIO fails to give decision on the request within the specified period, he shall be deemed to have refused the request. If the public information has failed to give the information within the specified or required as mentioned in the time limit in the Act, then it will be deemed to have been refused by the request. Information exempted from disclosure is discussed in section 8 of 1. Under the RTI Act, section 8 of 1, some of the informations which are exempted from the disclosure. The RTI Act has mandated the constitution of Central Information and State Information Commission by the central and state government respectively. Under this Act, Central Information Commission and State Information Commissions have been constituted. The Information Commissions will receive complaints from any person who is not able to submit an information request because a PIO has not been appointed or a PIO refused to forward an information request or appeal, who has been refused information that was requested, who has received no response to his or her information request within the specified time, who thinks that fees charged are unreasonable. Means the information officer has charged unreasonable amount for providing the information, then also he can make complaint against PIO, who thinks information given incomplete, false or misleading. In the case of information given by the public authority incomplete, false or misleading, then also he can make complaint against the information providing officer. Any other matter relating to requesting or obtaining information, in this case also he can make complaint. The Act prescribes two steps of appeal. Under this Act, two steps of appeal can be made by the public. First appeal lies to the identified appellate authority who is an officer senior in rank to PIO. First appeal should be preferred within 30 days from the date of issued order issued by the CPIO. The appeal should be disposed within 30 days from the date of receipt of the appeal by the appellate authority. Within 30 days, if the information given by public information officer is not satisfied by the applicant, he can make appeal to the first appellate authority within 30 days of the receipt of the CPIO. Then First appeal also within 30 days will be disposed by the first appellate authority. Second appeal can be submitted to the Information Commission. The second appeal should be made within 90 days from the date on which decision should have been made or was actually issued. However, the Information Commission can accept the appeal even after the expiry of 90 days time frame. It is satisfied by the reasons. The time limit for second appeal is 90 days. Even though 90 days also over, the applicant can give valid reason. If the valid reason given by the applicant is satisfied by the second appellate authority, then also we will make second appeal. Meaning of information. Information is any material in any form including records, opinions, orders, documents, advices, logbook, memos, press releases, contracts, emails, circulars, records, papers, samples, models, data material held in any electronic form. These informations will be provided to the applicant under this Act. Record, it includes any document, manuscript or and file, any microfilm, microfiche, facsimile copy of document, any reproduction of image or images embodied in such microfilm, whether enlarged or not, any other material produced by a computer or any other device. Right to information. The right to information accessible under the Right to RTI Act, which is held by or under the control of any public authority, includes the right to inspection of work, documents, records, taking notes, extract or certified copies of the documents or records, taking certified samples of material, obtaining information in the form of diskette, floppies, tapes, video cassettes, or in any other electronic mode through printouts where such information is stored in a computer or in any other device. Public authority. Any authority or body or institution or self-government established or constituted by or under the Constitution, by any other law made by the Parliament, by any order, by any other law made by the state legislator, by notification issued or order made by the appropriate government, body owned, controlled or substantially financed, non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. Appropriate government means in relation to a public authority which is established, constituted, owned, controlled or substantially financed by the funds provided by directly or indirectly by the central government or union territory administration, the central information, by the state government, the state government competent authority, the speaker in the case of House of the People or the legislative assembly of a state or a union territory having such assembly, and the state and the chairman in the case of Council of State or Legislative Council of State. In the case of House of People, the speaker is the competent authority, and in the case of Council of State or Legislative Council of State, chairman is the competent authority. The Chief Justice of India in the case of Supreme Court. The CJI is the competent authority in the case of Supreme Court. The Chief Justice of High Court in the case of High Court. The President or the Governor, as the case may be, in the case of other authorities established or constituted by or under the Constitution. The administrator appointed under the Article 239 of the Constitution. Third party, a person other than the citizen making a request for information and includes public authority. Third party means other than public authority, any official or third party who is, suppose if anybody anything information asked by the applicant by the working any official under the government, then the information will be third party information. Dealing with the information sought for by the citizens. Right to information includes work inspection of works covering taking the certified samples by citizens, keeping the importance attached to the citizens. Right to information. The Act bars the courts from entertaining any suit, application, or other proceeding in respect of any order made under this Act. No such order shall be called in question otherwise than by a way of an appeal under this Act. Seeking information is the citizen's right, and an applicant making a request for information cannot be asked to give any reason for requesting the information or any other personal details except those that may be necessary for contacting. It means that by submitting the RTI application, personal information will not be required to provide, and also reason for asking the RTI also will not be necessary. There is also provision for compensation to the citizens by the public authority concerned for loss or detriment suffered. If anything lost by the government or any public authority, compensation will be provided to the applicant. The PIOs are required to render reasonable assistance to applicants for information. Such help for the citizens could be made in any form as stated below. Where a citizen is unable to make a request in writing, the PIO shall render assistance to the person making the request orally to represent the same in writing. If any citizen unable to make a request in the RTI, PIO shall render assistance to the person who has required. Where the information sought concerns the life or liberty of a person, the PIO shall take all steps to provide the required information within 48 hours of the receipt of such request. If the information pertains to life or liberty of a person, the PIO should give information within 48 hours of the receipt of the such request. Next, when the person to whom the access to record is to be provided sincerely disabled, the PIO shall provide necessary assistance to enable such information, including such assistance is appropriate for the inspection. If anybody unable to file the application for the reason physically handicapped, then PIO will give assistance to enable the information, including inspection of work. As the right to information includes inspection of records, the PIO will reserve place and time for such inspection. PIO will intimate the place and time where he should inspect. Necessary arrangements have to be made to ensure that the citizens can carry out the inspection without any disturbance or distraction. The PIO would also make necessary arrangement for giving certified samples of material wherever required. Dealing with the appellate authorities, while rejecting request for information or intimating the fee amount to be paid, etc., the PIO is required to indicate the right to appeal, the details of the appellate authority to whom applicant can appeal. While rejecting the applicant request The information officer should intimate, if required, he can file the where he can file the appeal, or the details of appellate authority he will be mentioned in the application. The Central or State Information Commission, as the case, shall impose a penalty on erring PIO if in its opinion that PIO has, without any reasonable cause, refused to give reasons, refused to receive the application for information, not furnished information within the specified time, malfidly denied the request for information, obstructed in any manner the furnishing in the request information, destroyed the information which was the subject to matter of request. In the event of above, the Information Commission shall impose a penalty of rupees 250 rupees per day on the PIO till application is received or information furnished, subject to the total amount will not exceed 25,000. In the above cases means at the time of rejecting the application without a valid reason, or information not furnished, or malfidly denied, obstructed in any manner, or destroyed the information. In these cases, the Information Commission will impose a penalty of rupees 250 rupees to the Public Information Officer till he will receive the application or information furnished. Total amount will not exceed 25,000. The Information Commission shall also recommend disciplinary action against the PIO under the service rules applicable to him or her in certain cases. In certain cases, the Information Commission will also impose disciplinary action against the PIO. Every government, every department has appointed first level appellate authority who is senior in rank to the CPIO. If a citizen is not happy with the information provided by the CPIO, he can appeal to the first appellate authority within which is a departmental officer, and the first appellate authority has to dispose the appeal within the fixed time 30 days. If the applicant has not satisfied by the information provided by the CPIO, he can appeal the first appellate authority within 30 days from the receipt of CPIO. Then the first appellate authority also dispose or appeal within 30 days from the receipt of the application. If the applicant is not convinced about the dispose of appeal, he can approach the State Information Commission or Central Information Commission for getting the information. If the applicant still also not satisfied given by the first appeal also, then he can make appeal to the State Information Commission or Central Information for getting the information. The Information Commission is legally bound to give opportunity to the PIO to hear before deciding to impose a penalty. The PIO has therefore to prepare himself or herself to justify the action taken by him or her to prove that he or she acted reasonably and diligently. Next, needless to say that the PIO should keep the public interest paramount at all times. When it comes making a decision to determine public interest versus private interest, it is an important that the public information officer makes a decision after considering the legal position and all possible aspects of the issue at hand. Means PIO should give priority to public interest while giving the information to the applicant. Making a request for information under the Act. The information may be made go the Central Public Information Officer, State Information Officer of the concerned public authority, or given to the Central Assistant Public Information Officer or State Assistant Public Information Officer, as the case may be. Request can be made either Central Public Information Officer or State Information Officer or Assistant Central Information Officer or Assistant Public Assistant State Public Information Officer also. A request for information can be made as follows: in writing, through electronic means, English or Hindi, or in the official language. Applicant can be made RTI, English or Hindi, or the official language of the area also. Overall request has to be reduced to writing, and it is the duty of public information officer to assist the applicant where such request cannot be made in writing. Overall request as far as possible has to be reduced, and the PIO should assist the applicant where the applicant can make request. Specifying the particulars of information being sought by the applicant, accompanying the request fee as prescribed under the rules made under the Act. Disposal of request. The information shall be disposed by the public authority within public information officer within 30 days from the receipt of 30 days in general cases and 48 hours in where the information sought concerns the life or liberty of a person. In normal case, 30 days time will be there, and in case of the information pertains to concerns life or liberty of a person, then within 48 hours RTI can be disposed. A period of 5 days shall be added in computing the response time where an application for information is given to Assistant Public Information Officer. If the application received by the Assistant Public Information Officer, then 5 days extra will be added to the normal 30 days time. Within 5 days, he can forward the application. Next, forward the application to the appropriate public authority where information sought pertains to another public authority at the earliest, in any case not exceeding 5 days. Within 5 days, he can forward the application to the concerned authority. Request to be deemed to have been refused by public information officer if decision on the request for information is not given within the specified period. If the PIO has not given reply within time limit, it will be treated as deemed to refuse the information sought by the applicant. Where a decision is taken to provide the information on payment of any further fee representing the cost of providing information, the public information officer shall send an intimation to the person making the request. If the information asked by the applicant provided after making payment, then the PIO should intimate the applicant regarding payment of such necessary information. The details of further fees representing the cost of providing information as determined by him or her together with the calculation made by arrive at the amount in accordance with the fee prescribed, requesting him or her to deposit that fees and the period intervening between the dispatch of the said information and payment of shall be excluded for the purpose of calculating period. It means that the period which will be taken in case of providing information after the making fee paid, the particular time will be excluded for the normal 30 days time. It will not count in the 30 days time. That will be excluded. Next, scale of fees. The Department of Personnel and Training, Government of India has, under the Right to Information, Regulation of Fee and Cost Rules 2005, prescribed an application fee of rupees 10 rupees for request for obtaining information. If the information is required, 10 rupees has to be paid by the citizen for filing the RTI application. This could be in cash against proper receipt or demand draft, banker's checks, Indian postal order, or any other online payment. The applicant can be made payment through demand draft, banker's check, or Indian postal order, or any other online payment to the accounts officer of the public authority. Next, the Government of India Right to Information, Regulation of Fees and Cost Rules 2005 provide that the public authority may also charge the following fees for providing information. For 2 rupees in case of A4 size or A3 size paper, in case of providing A4 size or A3 size paper, the public information officer will charge 2 rupees per copy. Actual charges are cost price of a copy in larger size. In larger size, actual charges will be charged for copying charge. Actual cost or price for samples models. For inspection of records, no fees for first 1 hour and a fee for 5 rupees for each subsequent hour. If the applicant will wish to make inspectory any record for first 1 hour, no fee will be required. After that, 5 rupees for each subsequent hour. For information provided in diskette or floppy, 50 rupees will be per diskette or floppy charges. For information provided in printed form, at the price fixed for such publication is 2 rupees per page photocopy for extract from the publication. Next, information exempted from disclosure. Some of the information have been exempted. The Act provides a list of categories of information which are mentioned as below. Information disclosure of which prejudicially affect the sovereignty, integrity of India, security, strategic, scientific, or economic interest of the state, relation with the foreign state, lead to incitement of an offence. In case the information requested by the application which will affect the sovereignty, integrity or security, strategic or scientific or economic interest of foreign state, this information can be exempted from this Act. Information which has been expressly forbidden to be published by any court or law tribunal, the disclosure of which may be constitute contempt of court. Information, the disclosure of which any constitute content of code. Information, the disclosure of which would be cause to a breach privilege parliament of the or state legislator. In case of any information received by the applicant which will cause or breach the privileges of parliament or state legislator, that also exempted from the this act. Information including commercial confidence, trade secrets, intellectual property, the disclosure of which would harm the competitive position of third party unless the competent authority is satisfied that a larger public interest warrant to disclosure of such information. Information to a person in his fiduciary relationship unless the competent authority is satisfied that the larger public interest warrants to disclosure of such information. Information received in confidence from foreign government. Information, the disclosure of which endanger of life or physical satisfy of any person or identify the source of information, assurance given by the confidence for law enforcement or security purposes. Information which would impede the process of investigation or apprehension or prosecution of offenders. If information asked by the applicant is pertains to any investigation under the process which will cause the or which will make any distraction of that process, then also that information also excluded from this act. Cabinet papers including records of deliberations of council, ministers, secretaries, other officers, provided that the decisions of the council of minister, the reasons thereof, and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. Provided that further that those matters coming under the exemption specified shall not be disclosed. Information which relates to personal information, the disclosure of which has no relation to any public authority or interest or which would cause unwarranted invasion of the privacy of an individual unless the PIO or EU, as the case may be, satisfied that the larger public interest justifies the disclosure of such information. If the information sought by the applicant will provide or make any problem to the any person or privacy of the individual, then also that information will be exempted from under this act. Provided that the information which cannot be denied, the parliament or state legislator shall not be denied to any person. Thank you for watching. Please subscribe the channel.